Welcome to the fastaeconomicslaw.org Indaba. Indaba is a Zulu and Xhosa word that refers to a meeting to discuss a serious topic. It refers to a discussion on a matter of concern or for discussion. This occasional series will discuss issues relating to international economic law, relating to Africa, the developing world, and the global south. The discussion will prioritize bringing in expert voices who work very hard on the issues we care most about here. These individuals do so behind the scenes, as it were, invisible to our audience, we the academics, yet their insights are invaluable to the work we do. So having said that, I'm James Thuo Gathii, an editor at economicslaw.org and a professor of law at the Loyola University, Chicago School of Law. My first guest is my very good friend, Mustaqeem de Gama, who is currently a counselor at the South African Mission in Geneva. The South African Mission, of course, among other places, the WTO. He's responsible for intellectual property rights, dispute settlement, trade-related investment measures, and rules relating to all the trade remedy issues, anti-dumping, countervailing duties, subsidies. In his previous position, he was a director with the Department of Trade and Industry in South Africa, where he dealt with issues of investment and trade measures, and he was the lead person on the reforms of South Africa's investment laws. I must say, I met him a couple of years ago. He's really one of the best international trade and investment lawyers that I have ever met, and I mean that very seriously. So we're delighted to have you here, Mustaqeem. I know that my introduction has not done justice to all the things you do in Geneva, so maybe you can begin by telling us a couple of the other things that you do there in Geneva.
James, thank you very much. That's a very kind introduction from you. And certainly, yes, I would like to firstly say that the apt description of this conversation as an Indaba really captures the African spirit in which we do things. And I will bring it back to, our culture as Africans and what we expect when we move abroad. And so from that perspective, I've been in Geneva for the last 5 years or so. And so I've seen during this time 2 ministerial conferences. And at the moment, I'm well integrated into what we call the African group in Geneva. Mm-hmm. Now, the African Union is not a member of the WTO, but its members come together in an informal configuration that we call the African group. And so for purposes of the WTO, the African group really is the heart and soul of Africa's representation, but also Africa's participation in the World Trade Organization. And so from that point of view, I act in various capacities. For the African group, I act as a so-called focal point. Now, just to simplify it, focal point is really just the lead person on a particular topic. So for example, on e-commerce, this portfolio has been with South Africa. It's been with a previous colleague of mine. And so I've taken over this portfolio. And so I represent the views of Africa on e-commerce, services, for instance, domestic regulation, and certainly issues that have a bearing. I also deal with development in the context of developing country representation. So at the moment, South Africa is also the focal point or lead on issues of special and differential treatment and development. And so this is also an enormously important file, not only for Africa, but for all other countries. And so in this portfolio, we bring all of the biggest developing country groups together. That is the African group, the Africa, Caribbean and Pacific group, and the LDC group. And this is how we engage on development. Another file that I'm responsible for, and probably the hottest file in the WTO at the moment, would be the fishery subsidies file, where I am the lead for the Africa, Caribbean and Pacific group on fishery subsidies. And this certainly is one of the expected deliverables for the next ministerial conference. Over and above that, James, I also deal informally with issues on dispute settlement, for example. As you indicated, I also deal with rules-based disciplines, countervailing, anti-dumping, and so forth, issues of subsidization, for example. So quite a wide range of issues that we cover. Now, I have to say, I'm lucky. In my delegation, we probably have, at the best of times, 4 or 5 specialists that come and deal with these issues. At the moment, we are a bit low on staff complement. So I deal with agriculture, with market access, for example. I deal with the TRIPS Council. I deal with the Council for Trade in Goods and Trade in Services, and then also the trade-related aspects of investment. So these are broadly all the files that I deal with. But I have to say this is not exceptional, because the average size of African delegations represented in Geneva would be around 1 or 2 officials that would have to deal not only with WTO issues, but also, other UN bodies. So certainly this is an aspect that puts a lot of pressure on colleagues, on African delegations, because we just do not have the resources to effectively engage in every committee. And so this is where the African group comes in to provide a little bit more structure and representation, so that smaller delegations can participate more effectively. But at the end of the day, it is also about building the institutional framework, the institutional memory, which is so important for advancing our interest in the multilateral system. So in a nutshell, James, that's really what I do here. And at the end of the day, I think it's a labor of love. It's something that you have to love to do in order to stay motivated, because at the current point, the multilateral system is facing quite a lot of obstacles, and especially the interest of developing countries are not always captured in these narratives.
Well, thank you so much, Mustaqeem. I mean, it's amazing the number of things you're doing there. So I really appreciate you taking this time to speak to us. I believe that by speaking to us so that we understand all those issues you're saying, including the very low capacity in terms of personnel that many delegations have in Geneva, is an issue that I think we should discuss much more and should be much more widely known in light of some of the big issues we're going to discuss today, 2 of them. The first of which is very important, especially because, as you said, the size and perhaps sometimes the capacity of these delegations from African countries and other developing countries is not as robust as one would like to see in relation to the issues. So one would hope that as those of us on the teaching side of WTO often tell our students, the WTO is a rules-based institution. One of my very first classes that I teach, and I'm sure many of my colleagues who teach international trade law are very familiar with, is the institutional structure of the WTO, with a ministerial conference at the top, and the various councils coming under them, including the General Council. But also one of the most important committees in this rules-based institution is the Trade Negotiating Committee, which was established after the Uruguay round, because developing countries were very concerned that during the Uruguay round, they were negotiating with the Secretariat, that the Secretariat was overbearing, that the Secretariat was taking the positions of the Quad, the 4 biggest members now of the WTO, and not taking too seriously the interests of developing countries on the very important issues that were being negotiated in the Uruguay round. So the success in the development of the Trade Negotiating Committee, which would represent the interests of all the members so they could negotiate with themselves and not with the Secretariat, was a very important success. And I would like you to tell us, what is the fate today of the Trade Negotiating Committee? Does it meet? Is the WTO operating on the basis of the successes and the lessons that have been learned in prior negotiating rounds, so as to avoid the mistakes that happened in Uruguay, particularly on the issues of most concern to developing countries?
Yes, thank you, James. I think this is really a very important point that must be stressed, that what applies, or at least what one sees on paper, does not always apply in practice. And it is true for most organizations, including the World Trade Organization. Now, of course, we have to take our cue from the Doha Declaration and the Doha Development Round. And so the structures that you describe are those that are associated with the Doha Round. And certainly members have agreed to conduct their negotiations through these particular structures. And as you indicate, the trade ministers, they are essentially the highest decision-making body. If you look at Article 9 of the Marrakesh Agreement, you will see that the ministerial conference is the highest decision-making body. And in the absence of the ministerial conference, you find the General Council, but certainly the TNC, the Trade Negotiating Committee, is the central point for all negotiations under the Doha Round. Now, you will also understand that there has been some controversy as to whether or not the promises that were undertaken when the Doha Round was launched have come to fruition. The consequences, certainly of the Uruguay Round for developing countries, were that they had undertaken a whole lot of new issues that were introduced from the Tokyo Round codes and that were multilateralized during the Uruguay Round. And so many developing countries said that they would do this, but on the understanding that they would be compensated. And so expressly the following round, the following trade negotiating round, took this into account and was called the Doha Development Round. And so the expectation of developing countries were that their issues would be taken up. And these issues were taken up in various ways. Firstly, through the institutional mechanism, as you say, as a bulwark against, for example, the activities of the Secretariat. But more importantly, the Doha Development Agenda also set a sequence of issues to be addressed in the negotiating round, and that would essentially compensate developing countries for the sacrifices that they made. Now, not only were these promises not complied with, because the Doha Round is not yet complete. After more than 20 years, the round is still continuing. If you ask some people, they will tell you that the round has ended. And the round ended, according to some people, at the ministerial conference, the 11th ministerial conference the 10th ministerial conference at Nairobi. Now, technically, this is not correct, and we probably could get into those details a little bit later on. But long story short, a lot of the issues around the conclusion of the Doha Round also centers around the WTO Director General as the chair of the TNC. And so as the chair of the TNC, he is obligated to convene the TNC to essentially assess progress that is being made with the negotiations. I have to say that in the time that I've been here, the last 5 years, the TNC has not met in formal mode. That is to say, the TNC has not come together in formal negotiating mode. the TNC has been convened in so-called informal mode. This has also caused some concerns for developing countries because, as you know, the outcomes of negotiations are usually part of, the travaux, as you call it, and usually a record of the negotiation is an indication of what the members had in mind when they negotiated these outcomes. Now, if one does not have a formal record of these negotiations, it does place one in a little bit of trouble, because over time, there may be some members that advocate a specific meaning to an outcome, which originally may not have been the case. But who's to say whether or not that member is incorrect, because there is no record to fall back onto. And this has hurt us in many cases, for example, where there are no complete negotiating records, even of the previous negotiating round. And so the TNC as a mechanism was meant, firstly, to lock in the avenue through which members negotiate. Now, on various levels, one can also see that especially certain members have opted not to use the negotiating structures provided for under the Doha Development Agenda. So many members have now opted to address issues that are not mandated formally in the WTO through so-called plurilateral agreements. And so these agreements, for example, on e-commerce, on investment facilitation, on MSMEs, for example, these have no mandate, because it's quite clear in the Marrakesh Agreement that if members do not agree, if there is no consensus by members to negotiate on particular outcomes, then, legally there is no binding effect on these plurilateral outcomes. And so currently what you do find is that members, rightly or wrongly, and we could also get into that particular point, some members have opted to go outside of the negotiating structure by negotiating plurilaterals, as is currently the case. There is also a secondary way in which the negotiating function is being eroded. So instead of negotiating in the TNC and naturally the bodies that report to the TNC, what you also find is that many of the reforms are introduced and executed in the committees and in the councils that are responsible for various topics. So, for example, in SPS, in TBT, there have been some profound decisions that have been taken in the course of the work of these particular committees and bodies that have influenced, and I dare say changed, the rights and obligations of members. And so if you really think about it, Article 9 of the Marrakesh Agreement sets out the ways in which decisions can be taken. So, for example, you could have an authoritative interpretation. This is one of the ways of doing it, but most of these require either formal voting or they require a certain majority. And so to evade those procedural difficulties and hurdles, what happens many times would be that members that can will take issues into committees, and they will try to overturn and change the nature of the obligations of members. And in recent times, we've had many proposals in committees that seek to change commitments that members have taken without going through the amendment procedure provided for in the Marrakesh Agreement. And so from that point of view, the TNC has been marginal, it's basically been informational, and it's also been combined with what is called the heads of delegation meeting, which means that the TNC combines with the heads of delegation meeting, and the DG essentially presides over both of these meetings, and certainly sits on two chairs, and we know what happens when you sit on two chairs.
Yeah, so so this is really a striking example of a departure from the design that you say in the Marrakesh Agreement about how decision making should be made. And it turns out that the Director General, who heads the Secretariat, then becomes the person that determines whether or not the TNC first meets. And secondly, I guess that opens the door for the use of the councils as the places where the decisions that would otherwise be made by all the members in the TNC would be made. And as you say, there's no record. And I wonder, so I guess one of the most striking examples of this, of course, is the Doha Development Round. And you have documented what effectively is the disappearance of the commitment to development as time has gone over the last couple of years in the documents prepared by the Secretariat to the word development or to the issues in the Doha round. And I want you to give this very striking example of how the lack of the meeting of the formal meetings of the Trade Negotiating Committee and the takeover of lots of those types of issues in the councils, inconsistently with the rules-based system for decision-making, have really compromised the Doha round.
Yes, thank you, James. I wanted to say that the WTO is a member-driven organization. I think this is what we all say. But whether it is indeed true that is subject to interpretation, because one invariably would find that the strongest members have the most control over the system. I also wanted to say that in respect of the DG can only do what he or she can do. That is to say, if the DG is obligated to convene, for instance, the TNC, then the DG should do so. But necessarily, there are also other systemic issues which has resulted in the negotiating function of the WTO to come to a grounding halt. And so, under these circumstances, it's natural that when you have pressure in a vacuum, that energy will seek any avenue to escape. And so, this is really what you're seeing, and it's the same. For example, because the negotiating function is at a standstill, undue pressure was put for example, on the judicial function of the WTO, to such an extent that a member or certain members have complained that WTO judges or appellate body members or panelists would have overstepped and would have created law in areas where there were none and in areas where members did not agree that there should be any legislative action. So the chain reaction is really that you have an organization that has not been able to complete a significant trade deal in over 20 years, and the pressure kind of has been transferred to dispute settlement because that's where members try to settle their scores. And as a result, we know what now has happened to the crown in the jewel of the WTO. This has also now come to a grounding halt. So from that perspective, it's going to be important to just reference some of the consequences necessarily is that the committees, the various councils, become a breeding ground for so-called incremental reform. Now, this is very dangerous when you listen to people talking about the WTO. They say that the WTO is like a bicycle. It has to keep on moving. You have to keep on pedaling. And so, from that point of view, the whole objective of the WTO is based on liberalization. And so, if you stop liberalizing, you quickly find out that the organization becomes dysfunctional. But I think from a developing country perspective, that is not the truth. If you look at the Marrakesh Agreement, it recognizes also that the WTO must contribute to development and certainly increase the share of developing countries in world trade. And so part of the institutional setup in the WTO is also to bring developing and least developed countries on board and to integrate them into world trade. Many members contest this. Many members, especially your developed members, have the opinion that the WTO only provides an opportunity to participate on a level playing field. It does not guarantee a result, this result being development. So you have an opportunity to participate on equal terms, and the result is not guaranteed by any undertakings that you find in the World Trade Organization. However, this is also, from a developing country perspective, a warped view of things, because the World Trade Platform is not at a level playing field yet. There are big differences in the levels of development of members. And so, as part of the recognition of these differences, in the olden, or at least in previous times, countries were either classified as first world or third world, and with the second world being the former communist countries. Today, that terminology does not apply anymore, and so you talk about developed countries and developing countries. However, the GATT did recognize in Part 4 that there are differences between developed countries and developing countries, and so made strides to implement policies such as less than full reciprocity, implementing, for example, the enabling clause, which gave some additional preferences to developing countries in their own relationships, but also in relationships between developed and developing countries. So development as a core competence of the WTO has an historical antecedence and certainly is central to achieving the integration of countries that need this. And so from that perspective, the Doha Declaration, paragraph 44, speaks about development and about the need to make it more precise, concise, and implementable. And this has been a very long struggle, because up to today, the issue of development is still an open one, and one that is becoming more and more difficult to manage. And so at the end of the day, the core of the arguments that are being presented are contested by developed countries, because, as I indicated at the start of our talk, developing countries entered into the Uruguay round, made the concessions on the understanding that they will have a chance. So the Doha round is called the Doha Development Round, but if you look at the state of negotiations, and if you look at the state of multilateralism, development has all but disappeared from the menu. And so if we say that this is a rules-based organization, we also have to recognize that recognize that when you make a promise, you have to keep that promise. And this is in line with the Pacta Servanda rule, that if you undertake to do something, you have to do it. And so in this environment, it leads to a trust deficit. And so many developing countries do not feel confident that their issues will be taken on board. But certainly the other point is that not everything happens in the WTO. You will also have forces outside the WTO, for example, under regional approaches where FTAs are negotiated, that developing countries are put under tremendous pressure to agree to what is called WTO plus outcomes. And so I shall not say, but many developing countries are currently negotiating with much more powerful forces than themselves. And so in the end, it may be that they give up many of the flexibilities that they have at the multilateral level. And this has severe consequences for the right to development and for achieving the 2030 SDG goals as negotiated by members of the United Nations. So just in this context, I think we need to certainly look at some of the elements that are encased in this debate and development. But just from a systemic point of view, James, I can tell you that many of the expectations that developing countries had at the start of the round are being dashed. And certainly the geopolitical climate has changed. We also have the prevalence of unilateral trade measures that are being applied. And so this is also an indication that members, or some powerful members, are moving away from multilateral commitments that are inclusive and that protect your smaller members to more power-based relationships where might makes right, and recourse certainly would be harder to come by. So from that perspective, it is also important that through the process, we protect the mechanisms of the multilateral system that has an inbuilt equality or equalizer that would look at the interest of your weaker members.
So thank you. I agree that we are seeing a very difficult moment for multilateralism. It's a kind of repudiation, of a system constructed after the Second World War, with a central commitment to issues of development as modified in Part 4, as you say, of GATT. And we've been talking about preference erosion for some time, and now we're talking about beating back the Doha round, the Doha development round. And in fact, as you correctly say, there are some developing countries, including Kenya, where I come from, that are negotiating on their own, without sort of negotiating as a group in the context of the US-Kenya Free Trade Agreement. So there's certainly lots of dynamics going on here. I want to come back to the Doha development round, and in particular, the centrality of the commitment to development that was the key commitment to renegotiate, to initiating that round in 2001. And I want to see if you can tell us, from the perspective of what happened at the ministerial conference in Nairobi, and what may not have happened subsequently in the subsequent ministerial conference, where are we at, as you see it, within the WTO regarding the understanding of the members? You certainly have said that there's been a scuttling of the development agenda as understood initially in 2001 and its centrality. But where do you see things standing now, and where do you see things moving forward? And what can those of us who are very interested in this discussion and who want to engage or re-engage with it do at this point?
Yes, thank you, James. I think things are at a knife point. It's not for nothing that people say that we are at a seminal moment in the history of this organization, because you have two camps of members, and it may be a combination of developed and developing country members. But certainly, if we step back and we look at what happened at MC10 in Nairobi, it was the first time that you had such an apparent difference in opinion regarding the mandate of the organization. Some members feeling that the mandate in respect of certain things were accomplished, whereas some members and the bulk of developing members are indicating that these objectives had not yet been achieved. And so, as such, the Doha Development Round was then still current. But the consequence of this disagreement was that immediately after the round, you saw these disagreements finding shape in the so-called plurilateral initiatives, and these quickly accelerated and found form at the next ministerial conference in Buenos Aires, MC11, where you had what was called the joint statement initiatives on e-commerce, for example, on investment facilitation that were launched. And so this was quite a clear indication that some members felt that new issues needed to be added to the negotiating mandate. But I think at the end of the day, it's not just a disagreement about what the organization should be achieving, but it is also a disagreement about the accruing benefits to members. Because if you really look at the orthodox literature, you will find that the period from about 2000 onwards, maybe from 1995 onwards, was seen as a period of liberation, of growth, of globalization. But what is quite apparent, if one looks back, is that yes, globalization has had many benefits, but it has also created winners and losers. And so from that point of view, developing countries would not have gotten the biggest part of that dividend. That would have been quite clear. But what also becomes very important to assess the context of the centrality of development is the emergence of China and the transition from a dominant US around 2000, and within a very short period of time, 5 or 10 years, China became the counterpole, as it were, to the US. And so, in a very famous book, Francis Fukuyama indicated the end of history. And this is not the physical history of the world, but certainly it is the triumph of the ideology of the liberal democratic system of governance. But very quickly, China had established itself as a counterpoint, and many of the problems that we see in the WTO also relates to the type of economy that is represented. So on the one side, you have a market-driven economy, and on the other side, you have a state-led economy. And so as models for development, I can tell you that the state-led model represented by China has had many more benefits for its citizens. China has been able to take many of its citizens out of poverty through state-led measures. whereas the kind of market-led policies, including those prescribed through the Washington Consensus, privatization, deregulation, tended to concentrate power in the hands of private individuals, in corporations, and tended also to create a very big division between those who had a big part of the resources and those who had a diminishing part of the resources. And so this kind of 1% idea, started to emerge. So if you look at the contestation, you find that there are two competing models. And so the countries that developed followed more state-led interventions. If you look at the Asian tigers, it was a mix, but certainly governments played a big role in the economic progress that one saw. At the same time, many of the African countries, for example, were facing the prospect of their share of world trade being eroded. And so I think today we're less than 3%. We have 1.25 or 1.35 billion people. In theory, we have the biggest consolidated market through the Continental Free Trade Agreement, yet we constitute a minuscule portion of world trade. Vietnam has an economy that is much bigger than the entire African continent put together. And so from that point of view, one would see the structural ideological differences bearing on what happens at the WTO. So from that point of view, once China had successfully demonstrated that they could develop, certainly not yet a developed country, if as many developed countries are alleging, but China showed that you could develop. And so many developing countries are certainly asking the question, well, can we do what China did in such a short time? And the answer is ambiguous because many of the mechanisms that developing countries agreed to in the Uruguay round was essentially a kicking away of the ladder. So mechanisms that developed countries had for centuries to develop their economies were suddenly illegal. So for example, local content requirements under the TRIMS agreement are illegal. These are mechanisms that Alexander Hamilton, for example, used in the development of the American economy. Copyright laws were very lax, yet we have a TRIPS agreement that sets a minimum standard and permanently removes the space to maneuver for developing countries by imitation, by copying, by reverse engineering, and so forth. So we see an institutional setup that is hostile to the interests of developing countries to achieve their development goals. And so in this context, it was also important to create at least some flexibilities. And these flexibilities you find in 155 provisions of the WTO agreement, or the covered agreements as they are known. And the paragraph 44 of the Doha Declaration is a recognition that even though these flexibilities exist, they are couched in non-binding, flexible language, which meant that developing countries could not assert legal rights to the types of treatment. And over time, the negotiations on special and differential treatment, as conducted through the Committee on Trade and Development in special session, has looked at ways of concretizing and making more precise and implementable these provisions. As I indicated, there are 155 instances. Some of them are still applicable, some of them are not, some of them are time-bound, some of them have to do with technical assistance and capacity building, and some of them have to do with some policy flexibility that developing countries can rely on. Currently, in the negotiations in the CTDSS, the Committee on Trade and Development, in special session, there are only 10 of these provisions that are being negotiated. And so, if you really think of it, of the 155 flexibilities that you find in the WTO covered agreements, only 10 now are being negotiated, and this 10 is really a patchwork of various types of flexibilities. For example, one flexibility deals with infant industry protection. Another flexibility deals with balance of payment provisions, issues of flexibility around technical barriers to trade, sanitary and phytosanitary requirements, issues around trims, issues around technology transfer, for example. So the combination of these provisions essentially gives some space for developing countries to try to develop. Yet these 10, what we call agreement-specific proposals, have been rejected by developed countries, saying that developing countries do not need to invoke exceptions to the WTO agreements. And certainly this is not correct. I think even LDCs are finding it very, very difficult to cope given the current world circumstances. But what I also want to say is that many of the new members, so you have many members that have perhaps joined the WTO in the last 20 years. Some of them are called RAMs, recently acceded members, and they form a distinct group within the WTO. But if you look at the commitments that new members have to take in the WTO, I would say personally it's heartbreaking, because new members have to take commitments that are certainly WTO plus, that are much higher than even developed members would have undertaken. And so from that point of view, any new member that comes into the WTO faces the full brunt of the system, because they are required to take much higher obligations. And so it becomes questionable whether these members will ever be able to achieve the developmental objectives that they want to achieve. So James, from that perspective, there's a lot of factors that impact negotiations at the WTO, but the state of play currently is that we only have 10 agreement-specific proposals that we are negotiating on. And what we hear from developed members is that they are willing to consider 2, and these 2 provisions relate only to least developed countries. And so if that tells you anything about the status of development within the WTO, I think certainly it's a sad picture that's being painted.
That was a great response, Mustaqeem, and it's important that you laid a framework for thinking about the contest between the visions of development between China and the United States. I think that provides a great context for understanding some of the dynamics that we've had in the discussion today. But I also thought that I would end this conversation by remembering, as you indicated to me, the present South Africa got after the end of apartheid in the WTO, when you discovered that as a independent country from white racist apartheid rule, that the prior government had declared South Africa to be a developed economy, and Ambassador Faisal Ismail declared this to be a historic injustice. So I want to give you the chance to say something about that to end our conversation, because I think it's a very relevant reflection on the importance of the issues that you've been discussing with us today.
No, certainly, James. I think that that's really the point that we spoke about. South Africa was notified as a developed country, and in line with the racist ideology of the apartheid regime. And so what South Africa essentially had to do was to change that designation. So we had, in the WTO, you have the concept of self-designation. So we could change our designation from a developed country to a developing country. This is in name only, because we had undertaken obligations that are far above those that other developing countries had undertaken. And as a result, the flexibilities that we have now to implement, for instance, our industrialization policies are impacted by those particular obligations. And so if we wanted to change the legal commitments that we made, we had to renegotiate those. And those would be very difficult. So to give you an example, under the GATS, we have taken, many of the highest obligations, and certainly with very few limitations. And so when you really look at it, what you see is that even though nominally we are on the books of the WTO as a developing country, if you look at our tariff structure, if you look at the water between our applied and our bound rates, you'll quickly find out that we do not have the type of policy space that many developing countries have. And so from that point of view, it has retarded our ability to transform our economy, to uplift our population. And this has long-term developmental impacts, not only from an economic point of view, but I think also from a socio-political point of view, because like Africa, we have a big population of young people. And if the economy does not create the type of opportunities that you need for economic development, you find that you have all the other social factors that come in and that create problems for you. And so part of this big issue for us is the issue of employment creation. We are not able to create the number of jobs for the number of people that we have. And certainly also the prospect is that in terms of our trade policy, we have limitations insofar as we cannot use the type of tariff policies or defense mechanisms that would otherwise be applicable to countries that have designated as developing countries. So from that perspective, I think this legacy, this present, as you mentioned, remains a gift that keeps on giving, albeit in a negative way.
Well, thank you very much, Mustaqeem. I mean, this is really a great conversation that has given us a lot to think about, and certainly I have learned a lot. The fact that, as you say, that the rules are really consequential in terms of kicking the ladder away, as it were, is very well illustrated, not only by that discussion you've had about the commitments that the apartheid government made for South Africa before it became independent, but it's also a reflection of the nature of many rules of international economic law that are written in a way that makes it really impossible to reverse unjust legacies. As you say, South Africa would have to renegotiate. That's a really high barrier and an example of the way the rules entrench really unfair and unjust outcomes. I think this sets us for another discussion in the future, digging down on some of these rules. For example, on some of the trade remedy areas you mentioned, like in the subsidies area, with the illustration you mentioned briefly about the discussions on fisheries subsidies and how you see those discussions evolving. Hopefully you'll have time for us at some point in the next couple of weeks to come back and discuss those issues.
Looking forward to that, James. Looking forward to that.
Yeah, so thank you so much for being our first guest on this Indaba. I really appreciate your time. I know there are lots of pressures in Geneva with all those candidates coming to vie for the DG position, including all the many other things that you do there in Geneva, and I appreciate your time very much today.
Thank you for the invitation, James, and certainly it's been a pleasure engaging.
Excellent. Thank you so much.